All right. Let's see. All right. Good evening, folks. Welcome to Monday Night Law with still some technical difficulties, but I don't know why do they keep saying key frame rate too low. I don't know. I'll have to figure it out. All right. Now this is weird. Why is it
No YouTube.
changing up on me? The size here. It's all moved around. So I'll have to fix that. Let's see if we can make it bigger. Because we need it the right size. I want to let it go bigger. Doesn't make any sense. All right. Well, good evening, folks. Here we are. Let's see if this. Okay. Yeah, I'm wondering if because I tried setting this up on two different ones, but or it ended up setting it up different on the YouTube. So there might actually be two videos there. So with the real one, may have to actually cancel that one. Let's see. Let me see. Make sure we got this all right here. That's it's only showing one live. Why in the heck am I running into this freaking problem? Makes absolutely no sense. That's all right. We'll get her figured out. I did try to figure out where the heck that stuff is at. Something about keyframes. I don't know where in the heck that's at. So I don't know. Maybe somebody knows about that. It says Please use a keyframe frequency of 4 seconds or less. Currently, keyframes are not being sent often enough, which can cause buffering. The current keyframe frequency is 8.4 seconds. Note that ingestion errors can cause incorrect GOP group of picture sizes. Where in the heck would I fix that? Any of you techie gurus out there? Because I've already looked for it in this Streamlabs OBS. Can't seem to find it. So, and now, I don't know. Yeah, see, and it's not going like full screen. Oh, well. Should be streaming. Dude, no. So let's see. Where is see if this is working over on Streamlabs. And it's not. Oh. Why is this not working? Was before. Now it's not. Anywho. Streamlabs. Oh, Lordy. The joys. All right. Well, thank you all for being here. It's Monday Night Law, and I'm gonna cover a little bit about lawful notification letters and the petition, right? Ooh, speaking of which, better get this sucker out. Okay. Trying to watch watch the comments here. All right. Oh, hey Julie, how are you? Kelly, Diesel D's, my peeps from Patreon. Everybody's doing all right out there. Jason, Brenda, good to see you. Yo, Rex, what's happening, brother? Let's see. Anybody else here? Of course, there's Bob. Right? Maybe Adam Schiff crawled into my tower to erase all the Schiff made up references. Yeah, Brenda. Yeah, I get it, but where in the heck is the settings for that? I've been all through the Streamlabs, every single window and tab that I could freaking click on. There is no setting to change that, unless I missed it somehow. So, if anybody knows where that's at, let me know. I'm using Streamlabs OBS, not OBS Studio. Two different programs. Okay, so through all of that, all right, so we need to comprehend a few things first here. Hopefully, I can still get. Oh, of course, I can't. Maybe on this screen. Ah, yes, I can. Nice. Okay. Where would I be? It's gonna be in. Right here. Oh, good Lord. And then we want, where is it? There we go. All right. Now let's see if we can bring this up real quick. All right. Yeah, now see, now that it's like way oversized. How is that? Good Lord. This blows my mind. Literally just how can it be different? It's the same freaking screen. I wonder if I do it like this. Here we go. Still a pain in the but all right. So, first thing we need to comprehend here is what is the law? Right says the law. So we're going to talk about writing a lawful notification letter here. Okay. So with the lawful notification letter, you got to cite the law. So here's some law, because rights are actually the law, not the code. Remember, code is spelled C-O-D-E and law is spelled L-A-W. So here's the first fundamental principle of law. All men are created by nature free. Free is in opposition to slavery, but it also is free from governmental interference. That's what the word free here means in the context of the right, the law. And then equal. Equal as in no man or set of men are entitled to separate emoluments from the community or privileges from the community. We're all equal here, except for public servants. We're the masters and they're the servants. But when we're talking about rights and being a creation of God, when we're talking about the word equal, meaning no man has any higher authority over another man, period. Doesn't exist fundamentally and principally. So, and have certain inalienable rights, among which are enjoying and defending life and liberty. So, enjoying and defending life and liberty, acquiring, possessing, and protecting property. Well, property is actually an aggregate of guaranteed rights. You talking about personal property? You talking about real estate? Because that's not property. Not in this sense. Pursuing happiness and securing safety. We have that right. This is a right and power retained by man. Okay? So remember, free from any kind of interference. And we're equal, which means no man can dictate to another man anything. We have the right to pursue our own happiness and securing our own safety, not another man. Now, let's read Article 1, Section 4. Guarantee of religious liberty. The exercise and enjoyment. The exercise and enjoyment of religious faith and worship shall forever be guaranteed. Forever. No person shall be denied any civil or political right, privilege, or capacity on account of his religious opinions. Now, but the liberty of conscience hereby secured. That means that religion is the right to think for yourself. Conscience comes from constitution, the internal dictates of our mind. That's the liberty of conscience hereby secured. The guarantee of religious liberty is the liberty of conscience, the right to think for ourselves, going back to being free and equal and having the right to think for ourselves. No man or set of men have any authority over another man, period. I don't care if that's your employer telling you something. They're the servant. Servants do not dictate to the people, they're masters. So, fundamentally and principally here, damn this thing. really don't get it. How it could be so out of whack. I just don't get it. How? How has this happened? Should be pretty simple, straightforward. But, never is. All right. So now that we understand or comprehend those right there, now let's look at a couple of other things within this law, rights as the law. This is Declaration of Rights. This is laying down the law because, again, D means down. Declaration is clarify. Clarifying what? Because law is that which is laid down. This lays down the law. That's why this is Article 1. Got to lay down the law first. Because remember, we, the people of the state of Idaho, grateful to Almighty God for our freedom. We're grateful to Almighty God, not government and not any other man, to secure its blessings and promote our common welfare. Do establish this Constitution. Again, law is that which is laid down, ordained, or established. Here's that word, establish. Isn't the Constitution for the United States of America ordained and established? Well, that leaves laying down the law. Well, here it is, Declaration of Rights, laying down the law. The word right comes from the French word droit, meaning right or law. So this is the common law, the law that's common to all, and it's supposed to be self-evident. Shouldn't even need to write it down. But here it is. Now, actually, we're going to go over here. Now, I know that other constitutions don't have this same thing, but here it is. This is still a fundamental principle. Corporations, public and private. So pay attention. Section 7, acceptance of Constitution by corporations. No corporation other than municipal corporation in existence at the time of the adoption of this Constitution shall have the benefit of any future legislation without first filing in the office of the Secretary of State an acceptance of the provisions of this Constitution in binding form. Got to be bound by it. That includes the Declaration of Rights. Okay. Now, here's the key part. Right here. And that the policy powers of the state shall never be abridged or sued to conduct their business in such manner as to infringe the equal rights of individuals or the general well-being of the state. To put that in layman's term, no policy of a business can come in conflict, infringe on our rights. And you're supposed to be bound by this, because ignorance of the law is no excuse, and to know a thing, to be bound to know it, or regarded in law as equivalent. So you're already supposed to know all this. So that's part of your lawful notification letter right there. Now, back to rights. When a corporation does infringe on your rights, that's grounds to revoke their business license. Because what? and no special privileges. You see, it's a privilege to do business in our communities, and you got to seek permission. It's a privilege, not a right. And so, no special privileges or immunities shall ever be granted that may not be altered. So, ever be granted, that's the business license. That may not be altered, revoked, or repealed by the legislature, not the judicial. Because fundamentally and principally, all of it, not some of it, not most of it, but all political power is inherent in the people, not government. Government is instituted for their equal protection and benefit of the people. And they have the right to alter, reform, or abolish the same whenever they may deem it necessary. Whenever. And you got to go to the legislature to do that, not the judicial branch. This is the lie from the bar. Oh, you go to the judicial branch for everything. No, our rights to a Republican form of government here is the legislature. That's the court of justice. That's why we got to comprehend what the heck the right to peaceably assemble is really about. The people shall have the right to assemble in a peaceable manner. What? To consult for their common good, to instruct their representatives. That's right, because they're the servants. We're the masters. We dictate to them. We instruct them to discharge the duties of their office. To what? Alter, reform, or abolish anything and anytime we deem it necessary. And to petition the legislature for the redress of grievances. To alter, reform, or abolish, or to revoke a business license, that's done through a petition to the legislature, because that's a grievance. Okay? The petition is how we call them in to peaceably assemble, so that we can consult for our common good and to instruct our representatives to alter, reform, or abolish, or to revoke a business license. That is what the right to peaceably assemble is about. It is not about standing on a corner with a sign. That's called picketing, not peaceably assembling. So now that we know that, learn this, right? You should all know this by now. Some of you might be new, but we've been teaching this for 4.5 years, almost 5 years now. So there's the law that dictates the process that is due process of law from our rights, not from the Idaho Code. This is real law. No, the people retained all rights and power. Privileges are granted. Okay. Now we know all this. Okay. Now that we see this here, number 10, right? We'll read First Amendment. Congress shall make no law respecting the establishment of religion. None. No law. None. Or prohibiting the free exercise thereof. You can't make any kind of law that says, well, in a state of emergency, we can do this and we can mandate that. No, because a mandate is actually a writ of mandamus from a superior court to an inferior court, a lower court. It has to do with the judicial branch to provide oversight for itself. Would not apply to the people. So it's actually called a writ of mandamus, not to be confused with mandatory. Mandatory and mandates are two totally different things. So remember, Congress shall make no law established originally or approving the free exercise, or so Congress shall make no law abridging the freedom of speech. Congress shall make no law respecting or of the press. Congress shall make no law of the right of the people to peaceably assemble. And again, peaceably assemble and petition the government for the redress of grievances. Notice how that goes together. That's how we call them into assembly. The law dictates that we file a petition to call them into assembly. So, where do you think this came from? The reality is to petition the government for redress of grievances? No, legislature for the redress of grievances. Where do we establish justice? Where would we do that? So, you know, this is the thing. Like, some people will say, oh, well, the courts of justice, that's the judicial branch. Well, let's read from the judicial branch. The judicial power of the United States shall be vested in one Supreme Court, and not all judicial power, just the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. There's that ordain and establish again. The judges both of the Supreme and inferior courts shall hold their offices during good behavior and shall at stated times receive their services as a compensation. These are the emoluments of the office. Okay. The judicial power shall extend to all cases in law and equity. For suits in law, not at law. These are courts of law, not courts of justice. And more specifically, they're courts of admiralty. And who's bound by admiralty jurisdiction? Who's bound by this Constitution? Well, that'd be Article 6, right? The senators and representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath of affirmation. Whoops. Bound by this. To support this Constitution, not the code. This is a requirement. It is mandatory. But no religious test shall ever be required as a qualification to any office or public trust under the United States. Public trust. Taxpayer dollars. To receive the emoluments of the office, those taxpayer dollars, you got to be, shall be bound by oath or affirmation to support this Constitution, right? This Constitution and the laws of the United States, which shall be made in pursuance thereof, pursuant to this Constitution. Got to have personal jurisdiction and subject matter jurisdiction to make whatever it is you make. It has to be pursuant to this Constitution. And all treaties made, right, has to be pursuant to this Constitution, or which shall be made under the authority of the United States. Where do you get your authority? From this Constitution. Shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. So even something in the Constitution of the state that comes in conflict with this Constitution and the laws of the United States, which shall be made in pursuant thereof, is void for any effect. Now, Marbury versus Madison backs this up, but I don't need Marbury versus Madison, do I? Because that's what it says right here, as it is written from this Constitution that happens to be ordained and established as the supreme law of the land. There is nothing higher constitutional-wise, governmental-wise than this. The only thing that's higher than this is the law of the nation called America, the common law. The laws of the nation came first. Government, this is government instituted to secure the common law, to secure our rights as the law. Okay? So this is why none of their policy-making powers shall come in conflict with our rights, because natural rights and civil rights have absolutely nothing to do with the establishment, support, or management of government. Hale versus Henkel, American Jurisprudence, Volume 15, Civil Rights, Section 2. Nothing to do with the establishment, support, or management of government. That's the law that was created before government. Our rights came long and descended to the formation of the state. So how do we not know this? I don't know. Just totally freaking blows my mind how people don't know this. Okay? So everyone, all them members of the several state legislatures, the members, and all members of the executive and judicial, all of them, if you're in government, you're required to be bound by oath or affirmation to support this Constitution and all the laws that are made pursuant thereof. All right. So what would you put in a lawful notification letter? Your corporate policy has come in conflict with my right, the law that you're supposed to know about. But here it is, I'm putting you on notice of it. You're in violation of my right of religion, my liberty of conscience. You don't get to dictate to me through policy. Your bylaws of your corporation cannot come in conflict with our rights. And here's the rights they're coming in conflict with. Right? Now, go back over here. What's the law behind it? Right here. What's that say? Crimes, which are public offenses, those in law. This is a suit in law. In the body politic. Here's some of that law that's made pursuant to the Constitution. Now, when we look at this, a lot of people are familiar with, 241 and 242. Oh, civil rights, conspiracy against rights, deprivation of rights. What about this one? Damage to religious property, obstruction of persons in the free exercise of religious beliefs. That's 247. Intentionally obstructs by force or threat of force, including by threat of force against religious real property, any person in the enjoyment of that person's free exercise of religious beliefs or attempts to do so shall be punished as provided in subsection D. Punishment for violation of subsection A or C of this section shall be, if death results from the acts committed, violations of the acts include kidnapping or attempt to kidnap, aggravated sexual abuse, or attempt to commit aggravated sexual abuse, or an attempt to kill. Can't that be construed as an attempt to kill somebody? You know what I'm talking about. For any term of your life, or may be sentenced to death. That's how serious this is, folks. (18 U.S.C. 247). Under civil rights section, religion. Right? So this is what needs to be in the lawful notification letter. Let me see. There we go. Where are we? Oh, actually, that's the wrong one. That's the wrong one. We need this one. All right, here's the one that I put together quite a while back. So let's give you the opportunity to correct the errors that your corporate policy is in direct violation of our rights. The people of Idaho have been unlawfully deprived of the rights without due process of law under color of authority and color of law. Your corporation is here put on notice to cease and desist all trespass of the law, or we will pursue lawful action against the individuals. Notice the words I'm using. Individuals in their official capacity and or the corporate entity's business license and or bonds. Okay. Now, here's my statement of facts. All district health departments' orders are unlawful and wholly void for any effect. Marbury versus Madison. Anything in the Constitution or laws of the state to the contrary are notwithstanding. For rights secured by the Constitution involved, there can be no rule making or legislation which would abrogate them. Miranda versus Arizona. Okay. Already been to court, already been discussed. We don't need to go to court to discuss this. An unconstitutional act is not law, confers no rights, affords no protection, and it creates no office. It is in legal contemplation as inoperative as though it had never been passed. Norton versus Shelby. Okay, so that question's been asked and answered. That's, again, these two go to hand in hand, right? Well, that's the reason why actually all four of these go hand in hand, which is why I have them here this way. Void for any effect for fraud. This is also known as the Miller versus U.S. Evelyn Miller was the appellant from the lower court versus the United States. It was the United States versus Miller. But on appeal, it switched to case Stiles. Execution of process and the performance of duty by constituted officers must not be thwarted. But these agents, servants of a government and a society whose existence and strength comes from these constitutional safeguards, are serving law when they respect, not override, these guarantees. The claim and exercise of a constitutional right, which it should be a constitutionally protected right, cannot thus be converted into a crime. Now, everything I just went over, why I did that Why I put it in here? Because it's the law. There it is. What I just covered. Imagine that. Look at that. There they are. Bam. I also throw in our proverbial 643. That's, emoluments. Whoever being an officer, employee, or agent of the United States or any department or agency thereof, having received public money which is not authorized to retain a salary. Okay. Going back to what? Authorized to receive as salary, or rights secured by the Constitution. There can be no rulemaking or legislation would abrogate them. Null and void if it's repugnant to the Constitution. If it's an unconstitutional act, it's not law, confers no rights, and affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. Okay. And the claim and exercise of a right can't be converted into a crime. When they do, you got to do this, right? So no, you can't continue to receive that money as a salary, a pay, or emolument. Now here's your sentences of fine. Look at that. For a felony, $250,000 per individual. Now, for organizations, like hospitals or, any of those corporations, it's $500,000 a pop per corporation. So not only can you do the corporation, but you can also go after the individual who's trying to enforce this unconstitutional, unlawful policy. It's a policy, not a mandate. Again, it's policy. So this right here, see how short and sweet that is? Now, of course, you're going to want to change this to, to meet your needs with the first statement. All corporate policy that comes in conflict with my rights are null and void, right? Are wholly void for any effect. All of this still applies. Just your first little statement there. That's it. Whatever it is. This is all you need to change. The rest of it is perfect the way it is. Now, if you're in Idaho, listen carefully, folks. If you are in Idaho, I'm willing to help with this, okay? And the reason why I say Idaho is because I've already done all the work for Idaho. Now, for those of you who are not in Idaho and want to do that, you're going to have to go to your constitution and you're going to have to find all that stuff, okay? Yeah, this is so weird. Why is it not going full screen? Yeah, I don't know. I don't know what's going on there, why it's doing what it's doing, but should be good enough, right? I'm not in New York. If you're in New York, you help New York. I don't live there, not my state. Can't help New York. People, you're going to have to claim and exercise your powers. I can't do this stuff for you. Okay? You're going to have to learn how to do this for yourself. So I get that people want help. This is the help I'm providing right here, right now. This is it. Now, petition. Once you do the lawful notification letter, you afford them the opportunity to do the right thing, and they don't. One, it's a criminal complaint. Two, it's a petition, right? Now, actually, before I get into that, now I want you all to see this. Oh, I should just do it real fast. Rule 75. Rules of parliamentary practice set forth in Mason's Manual of Legislative Procedures. See, they have the power to make rules of procedure. Shall govern the House in all cases to which they are applicable. And in what? To all cases? Huh? That's right. Again, the Court of Justice. Reading means reading, folks. Okay. And in which they are not inconsistent with the standard rules or orders of the House or and the joint rules and orders of the Senate and House of Representatives. So the standard rules here, right? If parliamentary practice set forth in Mason's Manual of Speech shall govern the House in all cases to which they are applicable. Okay. The Senate rules say the same exact thing. So now, here's the 2010 edition. Oh, where? There's their list of motions and stuff. But see, this is for while they're conducting business, right? This is rules of procedure. Now, here's a parliamentary inquiry that Chris talked about. Chris did a parliamentary inquiry about, well, what's an emolument? Some of you may remember that. Dianne Feinstein, or no, was it Feinstein or was it? No, it was Pelosi. Asked Attorney General Barr to define what an emolument is. And he said, well, it's a stipend attached to some office. Imagine that. It's a paycheck. Oh, let's see. About that for voting and elections and all. Huh? Wait, what? A quorum must be present. Computation of a quorum. The Constitution dictates it must be a majority of both the House and the Senate to make a quorum. So, Constitution dictates what the quorum is. not Mason's Manual Legislative Procedure. What's that? Declining to accept elective. Oh, never mind. Evidence of election of membership. Let's see. What's that? Investigation of charges against members? Now remember, they have standing committees, right? There's standing committees that are there 24/7. I think it's part 10 anyway. Let's see. Calls for special sessions. Here it is. Part 10, investigations and public order. So, the right of a legislative body to make investigations. Investigations respecting members. Limitations on right of a legislative body to investigate. Method of investigation by a legislative body. Legislative investigating committees. Witnesses in legislative investigations. Compelling witness to attend and testify. Power to punish for contempt. Summons, subpoenas, and warrants. Right of investigating committees to sit between sessions. Imagine that. So, right? Reading means reading. So yeah, part 10 there, 561, section 795. I'm going to go into the. Ooh, why did that get so blurry? Oh no. Well, that's a bad one. Parliamentary rules. It is blurry, by the way, from the PDF itself. So it actually, on my screen, it's really blurry compared to what it looks like out there to you folks. So it cleans it up actually pretty good. But I am broadcasting in 1080i, or 1080p, whatever it is. So principles of parliamentary law. An understanding of parliamentary principles will simplify the learning and application of parliamentary rules. Parliamentary procedure is based primarily on a group of principles that underlie the scheme of parliamentary rules. Some of these principles are set out below. Thought of in terms of principles instead of rigid, detailed technical rules, parliamentary law is essentially logical, and simple. Gotta love that logic. Okay. Get this crap off of here. freaking Witham guy again. Get off my shit. So some of these principles are set out below. That's what we're going to read here. There's some, it's below, but every deliberative body is bound to comply with all applicable rules laid down for it by the Constitution, judicial decisions thereon, and basic legal principles. These rules and principles govern whether adopted by the body or not, and they apply whenever group decisions are being made. Failure to conform to them invalidates any action taken or decision made. That's because it's fraud, right? And fraud vitiates everything from its inception. Avoid ab initio. I mean, that's just the way it is, right? So this guy off my stuff. So, you know, reading means reading, right? That's why we're here. Oh, man. Hmm. These kids, you know. And we get rid of trolls. That's how we do that. You want to talk your crap, you go do it on your own channel, not on mine. Your right to freedom of speech stops where mine starts. So, remember, failure to conform to them invalidates any action taken or decision made. So think about this for a second. In order to know if it fails to conform to these constitutional provisions, don't we have to know the law first? This is the problem, folks. Nobody knows the law. Oh, wait. Wrong mouse. Wonder why that wasn't working. So, unless restricted by the Constitution or other superior authority, a legislature can adopt its own rules of parliamentary procedure by a majority vote. Also, by a majority vote, it can change, suspend, or repeal the rules at any time it chooses. Failure to comply with its own adopted rules does not invalidate actions of the legislature. That comes in conflict with what was just said above. Failure to conform to them invalidates any action taken or decision made. So which is it? Well, unless restricted by the Constitution or their superior authority, the legislature can adopt its own rules of parliamentary procedure by a majority vote. Yes, they have the power to make their own rules of procedure, but the fundamental principles of parliamentary practice come from the common law. And like, well, every member of the legislature is presumed to be equal of each other member, and each has rights that must be respected. The rights of the minority and the majority both must be protected. Now, this is that 10 principles that govern procedure and group decision making. Some of them principles. Okay, here we go. The group must have the authority to take the action it purports to take. Jurisdiction must be given. It cannot be assumed. Groups sometimes assume powers that they do not have. So again, fundamentally and principally, we're acknowledging fundamentally and principally that they sometimes assume powers they don't have. Isn't it up to us to provide oversight of that? Yes, it is. But see, what are we talking about here? Jurisdiction must be given. Has to come from the Constitution. Has to be pursuance thereof. Right? Because that's fundamentally and principally how that works. The people delegate the powers by Constitution and creates the emoluments of these offices. Not them. Servants don't get to create the emoluments of their offices. We do. They're supposed to be the servant, discharge the duties of that office. Okay. Oh, wait. No, I was going to go to the Idaho one. Now I've lost what I was looking at. Oh, yeah, jurisdiction. Watch this. Right in the Idaho Constitution, right? Legislative Department. What's that? Unity of subject and title. Subject matter jurisdiction. Every act shall embrace but one subject and matters. This is subject matter jurisdiction, which subject shall be expressed in the title of the act. But if any subject shall be embraced in an act which shall not be expressed in the title, such act shall be void, only as to so much thereof shall not be embraced in the title. Right there. Subject matter jurisdiction. And if you've got anything else in that act that doesn't have anything to do with that subject matter, it's void. This would apply to what? I don't know. Them acts, they say bills, but they're acts, right? 4,000 pages or 9,000 pages. Yeah. And it's also required to be read 3 times. Did you read them all? Every last page and every word? Does that act only have one subject in it? If it has multiple subjects, well, guess what? It's void for any effect. Fundamentally and principally, it's void. Not from the day we go to court and brand it unconstitutional, from its inception. Number 2, principle. There must be a meeting of the decision-making group, a meeting of the minds, a quorum, when authority is vested in any group. It is vested in the group collectively and not merely in the individual members of the group. Imagine that. To make a decision, the group must meet and make up its collective mind. Oh my gosh, this would be like contract law. And number 3 principle here. A proper notice of the meeting must be given to all members of the group. All members of the group are entitled to such a notice of the time, place, and purpose of the meeting as will enable them to attend and participate. Failure to give such a notice will invalidate actions taken at the meeting. That's because you can't have secret meetings in our form of government. This is a fundamental principle, and it will invalidate any actions taken at any of these meetings without proper notice, fundamentally and principally. There must be a quorum present at the meeting. The quorum is a sufficient number of proportion of the members as will qualify those present to act for the entire membership. A quorum is a majority of the members qualified to act unless a lesser number is given that authority by proper authority or a higher number is especially required. Well, the Constitution dictates what a quorum is. And you can't subvert the requirements of the Constitution. A member who is not entitled to vote on a particular question cannot be counted to make a quorum for voting on that question. There must be a question before the group upon which it can make a decision. Well, should we make it mandatory? That question doesn't have any lawful authority in front of any group. None. Now, here's some more schmoo for you. The question may be a court-made law, including provisions of constitutions and charters. Oh, wait, that doesn't. Whoops. We got to skip. We got to skip back over here. We got to continue on. It's on the other half. Finish number 5 here because I was like, no. That's missing. Motion, resolution, or other proper form may be oral or in writing, and in most cases should be capable of being answered by an affirmative or negative vote. The member has the right to know what the question is and what its effect will be before voting on the question. Number 6, there must be an opportunity to debate the question. This is open for remonstrance and address. So, an opportunity to debate is necessary to enable the members of a group to reach a collective judgment. A member has the right to express personal opinions and hear the opinions of other members. Now, least not we forget that the people have the right to remonstrate here during the making process. This is why we have the Open Public Meetings Law. That's right. So, the question must be decided by taking a vote. It's not enough to presume how a member will vote. A vote actually must be taken. It must be taken by an authorized and fair method. There must be a majority vote to take an action or decide a question. In order to take any action or decide any question, there must be an expression of the will of the majority. This is usually a majority of the legal votes, but sometimes a majority of the entire membership or a 2/3 vote is required. A minority vote or a tie vote will not take any action. Now, here's one of my favorites. Number 1 and number 9 are my 2 favorites of these fundamental principles of parliamentary practice. There must be no fraud, trickery, or deception resulting in injury to another member. The person is entitled to the protection of the courts from injury through injustice by a body making a group decision, as in any other situation involving injury. Now, this is the only time that we would go to the court regarding the legislature, and that is a challenge to the constitutionality of the act. This is the primary function of the judicial branch, to provide oversight of the legislature. Number 10, to be valid, any action or decision of a body must not violate any applicable law or constitutional provision. Wouldn't our rights be applicable law? Yeah, I would think so, because they stand on a higher plane than the Constitution. Because that's part of the common law, the fundamental law. It's supposed to be self-evident. Oh, they don't want us to know that our rights are actually the law. The Idaho Code's the law. No, it is not. See Peterson versus Peterson, Idaho Supreme Court, Judge Eisman, 2014. The Idaho Code is not the law because they don't have any legislative authority. And the legislature can't delegate its powers to any man or set of men. See where I'm going with this, folks? So the decision-making procedures of anybody must comply with the applicable provisions of any local, state, or federal law. It is governed by any statutory or now statutory court-made law, including provisions of constitutions and charters. Except for in our form of government, the judicial branch doesn't have the power to make law. Now, do they? Considering Congress doesn't even have the power to make law. That's prohibited in Article 1. Or Article 1, as in Article the First of the Bill of Rights, commonly referred to as the First Amendment. But in reality, they're articles in addition to, and an amendment to the Constitution, not amendments. It's what it says on the top portion of the Bill of Rights. So this is fundamentally flawed. Court-made law. Court doesn't get to make law. So I'm going to stop there for tonight, because I know that's probably quite overwhelming just in that little bit right there. Right on. Diesel D sharing that Patreon out there. Right on, brother. So yes, Patreon, that's a good one. Wednesday night workshop. Now, I've sent out messages to those that are on Patreon for the Wednesday night workshop. Make sure you check your messages. And when somebody's out there saying that they didn't get to get in there because they didn't get a link or something, well, I went and checked. Sure enough, I sent you the link. I sent you the message. Now, whether you went back and got that and got in there or not is, I'm not responsible for that. You're responsible for that, not me. So, yeah. The other part is, again, I've got that streamlabs.com, or yeah, is it .com? Yeah, it is. Let's see if I can put that over here real quick and just show you. Just got this set up. Oh, but this isn't the one. I'm gonna have to go. Whoa, what did I do with that? Gotta love it. Okay, we'll go over here. I think. Oh wait, I should have that in. Where's it? There we go. So digital donations to help support the channels and everything else we got going on. You'll come to this page here. This is the donation page. This is just how it comes up for some reason. Now, as far as I know, you don't actually have to create a username, but you might. But if you click on this icon up here, it'll take you to the main page. And as you can see right now on here, which you can watch from here, you can watch the live feed. This is the software I'm using. It provides a website for me. So here it is. And you can make donations right here now that you can watch from right here. And you can see all the YouTube comments over here. Okay. And then, of course, over at the office for the non-digital donations, for that postal money orders, regular money orders, cashier checks, anything like that, gold, silver coinage, cash wrapped aluminum foil, send that over to the office at 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. And I want to thank all those that have supported, given their support over the time here, and greatly appreciate you. And of course, everybody on the different respective teams now. We've got a couple of different teams going on, working on the school stuff. And then, of course, my team at the office, team behind the scenes right here, right now. Thank you all. Thank you for being here. And I want to thank everybody for their likes, their follows, the shares, thumbs up. I know it seems to be a little difficult to share some of this stuff. So hopefully some of this stuff gets fixed. But tell your friends, right? And again, I do want to go back to reiterating about Idaho. I'm willing to work with people in Idaho with the lawful notification letter and standing up against this stuff and petitioning the legislature and filing criminal complaints. Okay. For Idaho. Okay. Other than that, you'll have to either get into Patreon, is where it's really going to be at, is the only other help I'm offering right now. But I'm still not going to come out to, you know, any other state and come help, because I'm in Idaho. So I've already learned my lesson on this. Need to stick to my home area and deal with what I need to deal with here. And at this point, just lead by example. You know, I can talk, I can lead a horse to water, but I can't force the horse to drink. So for some other state and for some other people, when I need to be here doing it for myself and doing it for my state, and just lead by example, get her done. So much love to everybody out there. I want to thank y'all for your prayers too, and ask for continued prayers as things get a little more heated up. Oh, I took that to the office today, didn't I? My letter. Yep. So I did show that Sunday yesterday was doing the test and tune stuff, but I received my letter from the Boise City Prosecutor's Office stating that there's no opposition to the consolidation of the cases. So now we're waiting for is the order for it to be done. And then it's go time with the request for discovery. Yep, I know. I just had enough. I've had enough of the crap. And for the last 20, almost 27 years now, I've been studying. Now, granted, it hasn't been every single day of my life. Now, up until I would say probably 7 years ago, wasn't almost every day. But there were times back when I first started, it was every day for quite some time. I went in spurts, sometimes it was like break up with a girlfriend. I'd go in and hibernate. What I do? Read the law, study the law. So, but with the recent past, with what was going on with the Hammonds over there, is when I really, it's like, okay, this is it. It's go time. And I've been nose to grindstone, nose in a book for the last 7 years. Let me tell you, many, 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 many hours every day for months on end. 12, 16-hour days. Started out in that family law non-movement. And I apologize to you out there but the fact is that's what my conclusion that I came to was there's no movement. That's the problem. There's no movement in the alleged family law movement. We got to make a law. We got to make a law. No, you need to read the law. It's already there. So they can't seem to quite grasp the concept that the law is laid down prior to instituting government, that is the reason why government was instituted, to secure the law. Congress shall make no law. They don't have the power to make law. They only have the power to make regulations. That's right. To regulate those in commerce and declare war. That's about it. Federalist 45 talks about that. That's pretty much the limitations of the federal government. And the powers that are delegated there are not limited to the states, right? Are reserved, respectively, reserved to the states or to the people. Bingo. But if all power is inherent in the people, then we have all the power. They're just servants. They only have powers that were delegated and under certain subjects that were delegated. Gotta have subject matter jurisdiction. And if you don't have subject matter jurisdiction, it's void from its inception. So, again, if you don't know what the limitations are of government, you don't know what the real law is, how are you going to know what's fraudulent? How are you going to know what's void for any effect? You have to know the law first. You have to know how our form of government is supposed to work. You have to know the limitations of our government first in order to know what's fraudulent. Otherwise, you're not going to know. Or you might go, well, that seems wrong. Yeah, your gut feeling might be right. But where's your law? Where's the law behind it? Where's the law of the land? Where's the constitutional law? Where's the common law? Where's the rights behind it? Like Carl Miller used to say, if you've got a right and you can articulate that right, you have that right. So, do you know your rights? Like the right to petition the legislature for the redress of grievances? like the right to petition the legislature to alter, reform, or abolish anything at any time we deem it necessary? How about your right to abolish or revoke a business license? Them privileges to do business in our communities. Do you know how that right works? Probably not. Probably the first time you've heard it, unless you're a long-time follower here. So for all the new people out there that have heard this for the first time to start learning what your rights are, the real law. Rights to Republican form of government. Those are them powers retained by the people. You can't effectively claim and exercise and defend your rights if you don't know them and you don't know due process of law. You're never going to get anywhere. So, much love, everybody. I'm glad to see, more and more people are starting to show up here. Numbers are starting to reflect it a little bit. It kind of comes and goes, but I know with a lot of things that are going on out there, this is prime time. There's lots of other people out there live right now. So again, I want to reiterate, thank you for you patriots that are here right now, because you could be somewhere else, but you chose to be here. And I have a sneaky suspicion why you're here, because nobody else teaches remedy and relief. Not even Chris Ann Hall. They don't teach remedy and relief. They get you all hyped up about your rights and how what they're doing is wrong, but they never teach you how to file a criminal complaint, how to do a tort claim, how to do a petition to the legislature for the redress of grievances, to alter, reform, or abolish it. No, it's always, well, file a lawsuit, go to the judicial branch. These people don't even know how our form of government is supposed to work. They don't know what our rights are that dictate the process that is due. That we can claim and exercise these rights, these powers, and how they work. But that's why you're here. So thank you, and God bless you all. And man, this showdown's coming, folks. I'm telling you. My case, our cases, I'm going to show you how it's done. That's all there's left to do. Lead by example. To quote Carter Miller, somebody ought to do something about that. Be a somebody. Do something about it. That's why we're here. That's why I'm here, trying to educate, showing the letter of the law, what it says as it is written, not my opinion. I didn't write it, but I sure have read it, comprehend it, and understand it. I stand in agreement with it. And anything that comes in conflict with that, well, that would just be void for any effect. Now, wouldn't it? All right. God bless. Much love. See you on Patreon, you patrons. See you on Zoom Wednesday night. Much love. Good night, everybody.